Hello, bonjour. I'm very happy to be in this beautiful city at this very important conference. I'm going to be talking about municipalities and the regulation and management of GHGs, something that hasn't been touched on yet. So briefly, what I'm going to cover, I'm going to talk a little bit about municipalities and greenhouse gases and climate change, and then just go on to the tests that courts have used in interpreting municipal power and authority under the provincial legislation that creates them. First, just looking at it generally, and then next at specifically with respect to greenhouse gases, using a hypothetical case that will test, that will use these general tests to see what authorities a municipality might have in direct management of greenhouse gases. And then I'm going to look briefly at other contributions that municipalities can make to greenhouse gas emission reduction and management, which is really, I think, quite significant. Now, my presentation focuses on mitigation, like everything here, just about, and not adaptation, although I do want to say municipalities do have a huge role in adaptation, the recognition that climate change has occurred and is occurring and will continue to occur, and so municipalities have to make a lot of changes in their environmental management and their emergency response management and the like in order to adapt to climate change. But I'm talking today about mitigation, primarily about mitigation. Okay, so municipalities, this is just a map of Alberta and Saskatchewan, or at least parts of those two provinces. And you'll see that, municipalities traverse this whole landscape. There are, I don't know how many, dozens and dozens of municipalities here. And in fact, there's municipalities cover pretty much the whole entire Canadian landscape, except perhaps in areas of just pure public land. And what's really remarkable about them is that each of them is, created under some provincial or territorial or federal legislation, and they have the powers that they have, but they can all be different from each other as well within those powers. Some can use their powers for more environmental conservation, stewardship purposes, some for, kinds of activities that are not so friendly to environmental conservation and stewardship, and to greenhouse gas emissions. So there's really a lot of leeway within their powers. And this is because municipal powers related to greenhouse gases is very large and very broad. For example, municipalities generally have power over local development, and local development can, for example, require buildings that will have the fewest greenhouse gas emissions related to them, or buildings and urban sprawl and the kinds of activities that will lead to greater greenhouse gas emissions. Businesses, transportation, roads, zoning, land use, waste management, garbage control, recycling, landfills, municipal infrastructure. Municipalities have control over their own infrastructure, and they can either be retrofitted or not to reduce or to increase the greenhouse gas footprint, and more. In fact, the Federation of Canadian Municipalities, which is a group of about 2,000 Canadian municipalities, states that about half of greenhouse gas emissions are, quote, under the direct or indirect control of municipal governments. And as well as, having so much control over the production and management of greenhouse gases, municipalities also bear the brunt of climate change by fires, floods, droughts, transportation disruptions, impaired air quality, emergency response, health issues, and so on. Yet municipalities are not seen as frontline players in climate change control and in GHG mitigation. I mean, this conference is primarily about the federal government and the provincial government, and it's their very important roles. Now, one of the reasons may be because there is no constitutional head of power for municipalities. All municipal powers are derived from provincial legislation, as provinces, at least under our Constitution, are given legislative authority over municipal institutions. So every province has some kind of legislation that creates municipalities and gives them powers, and may have other legislation that gives municipality authorities. And so they establish municipalities and set out what they can do. So what can municipalities do? As I said, first I was going to talk generally about what they can do, what they can legally do, and in particular if there happens to be federal or provincial legislation in the same area. And then isolate the discussion and focus on this case study of a greenhouse gas bylaw. So when we talk about municipal authority under legislation, we're talking about statutory interpretation. We have an act, say in Alberta, the Municipal Government Act, and if someone wanted to know whether a municipality had a power and the authority to pass a certain bylaw, you would apply tests that the courts have set out over the years. And one of the grand old test is the test of John Dillon, a U.S. federal court Iowa judge, who said with great authority in the early 1900s, "It is a general and indisputed proposition of law that a municipal corporation possesses and can exercise the following powers and no others. First, those granted in express words. Second, those necessarily or fairly implied in or incident to the powers expressly granted. Third, those essential to the declared objects and purposes of the corporation, not simply convenient, but indispensable. And any fair, reasonable doubt concerning the existence of the power is to be resolved by the court against the corporation, and the power is denied." Okay, so that very strong statement was adopted by our Supreme Court of Canada in R.V. Greenbaum in 1993. So that's that in that way the courts seem to treat municipalities like with a lot of suspicion and like they're really trying to get away with something when they're passing their bylaws. And I think it's really unfair, and thankfully I think this test has been loosened and liberalized over the years, because municipalities, although they are creatures of statutes, as is said, I mean, they are living creatures. And although the statutes give them life, they have a life of their own as well, and responsibility over all their citizens and the health environment within their regional boundaries. So they have a lot more going on than just little creatures of statutes that have one or two authorities. They have a lot of power and responsibility. So as I'm going to say, the Dillon's rule, although it still is applicable to really express grants of authority in statutes, it has been softened. But the first thing you would look at if you wanted to know whether a municipal law, which would typically be a bylaw passed by a municipality, if it was within its power to pass that bylaw, you would look at the purposes of a municipality under the legislation, because a municipal bylaw must be within the purposes of a municipality. So municipal legislation, wherever you are in Canada, will typically set out purposes. Why are there municipalities? And the leading case in this is Shell Canada Products versus Vancouver, where Vancouver passed a law, this time by resolution, not to do business with Dutch Shell until it withdraws its activities from South Africa. And the Supreme Court of Canada, when that was challenged by Shell, said that was not within municipal purposes, that was more like just a political boycott generally, because a bylaw must be within purposes, it must benefit the municipality in some way, the health, the environment, the well-being of the municipality itself. Another really important case in testing municipal authority is the spray tech case, a case that arose out of the town of Hudson in Quebec. This is a softening of that Dillon rule. The bylaw in question prohibited the aesthetic application of pesticides. The town of Hudson, taking a precautionary approach, passed a bylaw that said you cannot generally apply pesticides just to get rid of, say, dandelions or weeds because of the potential health impacts. Now the town, I think it's important to note, passed this bylaw under what's called its general bylaw making authority. Municipalities typically have general bylaw making authority, which is couched in big, broad language, like this one was a municipality could make bylaws to secure peace, order, and good government. We've heard that bandied about today. Health and general welfare in the territory of the municipality. So this is really big and broad. It's not really express the kind of powers you might find under, say, municipal taxation powers or municipal powers to control development or subdivision or property rights, which would be more express. And as a general rule of thumb, the more express a power, then the more that Dillon type way of interpretation will apply. And the more general, then we're looking more at spray tech. And in the spray tech case, the Supreme Court of Canada found that yes, the town of Hudson did have the right to pass this bylaw. It didn't matter that there were other laws in the field. There was a provincial law and a federal law kind of in the field, but didn't regulate exactly the same thing. It didn't matter that there was no specific authority in the Towns and Towns Act, the legislation under which this bylaw was passed. And even if there are laws, provincial or federal laws, they can still, the bylaw can still stand unless there is what the court called the impossibility of dual compliance. So as long as it's possible to comply with the laws of the other jurisdiction and the municipal law as well, the law will stand. And so a municipal law can be more strict than a provincial law or a federal law and still stand. The next big test is the Rothmans, Benson and Hedges versus Saskatchewan test. In this case, you had a federal law, the tobacco legislation, which permitted the open display of tobacco products for sale, and a provincial law that prohibited it, where youth may be present. Well, Rothmans and Benson and Hedges alleged that the laws conflicted, and the federal law would be paramount and would prevail over the provincial law. The Supreme Court of Canada said no, there was no conflict in the sense of impossibility of dual compliance, because you could comply with both laws, federal and the provincial, simply by complying with the provincial law. The federal law was permissive, but it wasn't mandatory. It didn't say that tobacco products had to be displayed at retail where youth was. It just said it was okay. So, but what the court did do is it added another test to the test of a validity of a municipal, well, in this case, a provincial law, but it would apply to if you were looking at a municipal bylaw and a provincial law as well, is that a law provision may be inoperative if it frustrates the purpose of the law of the other jurisdiction. And in this case, they found no such frustration. In fact, it enhanced the purposes. It was made for very much the same purposes. Then there's the final test is the express legislative test. And this is where spray tech doesn't apply, the impossibility of dual compliance, because legislation sets out some other test that applies. And the case I'm using here is Peacock versus Norfolk County in Ontario, and it's where the Peacocks wanted to enlarge their intensive livestock operation, and they got a provincial permit to do so under the Nutrient Management Act, a regulation under that act. However, they couldn't get a development permit from Norfolk County because Norfolk County had zoned that area to be intensive livestock operation free. It was a no-go zone, so they wouldn't give them a development permit. The plaintiffs said that there was a conflict in provincial paramountcy. The defendant said no conflict, no impossibility of dual compliance, simply don't enlarge your intensive livestock operation and you comply with both. The court said that spray tech did not apply because there was an express legislative test and because the Nutrient Management Act stated that a regulation supersedes the bylaw of a municipality or a provision of that bylaw if the bylaw and the provision address the same subject matter, pretty broad, as the regulation. And since the plaintiff got its provincial approval under law that addressed the same area, the provincial law prevailed over the bylaw, and the bylaw was inoperative. Okay, so those are our tests that one would use to determine whether a municipality, whatever kind of municipality we have here, a town, an urban, rural municipality, try to, in some ways, regulate greenhouse gases. So there's Dillon, there's Purposes, Spray Tech, Rothmans, and Express Legislative Test. So here's my my case study. It just came straight out of my head. It's not a real municipality. I call it Greensboro in my paper. And Greensboro has passed a bylaw in which it regulates the emission of a greenhouse gas, namely landfill gas, which I'll talk about in a second. Then we're going to apply these tests to see whether it has a right to pass this bylaw. We'll say that it puts a direct numerical type limit on how much of the landfill gas can be emitted into the environment. Since I can't do all of Canada for many reasons, I'm just going to use Alberta as an example and assume for the purposes of this discussion, and in much more detail in the paper, that the Greensboro is in Alberta, and so we'll be looking at the Municipal Government Act. And then I'm going to briefly talk about charter cities because they're in a little bit different situation than ordinary municipalities like Greensboro. Okay, so what is landfill gas? Landfill gas, this is the EPA talking here, is a natural byproduct of the decomposition of organic material in landfills. Landfill gas is composed of roughly 50% methane, 50% carbon dioxide, and a small amount of non-methane organic compounds. Methane is a potent greenhouse gas, 28 to 36 times more effective than CO2 at trapping heat in the atmosphere over a 100-year period. And Environment Canada and Climate Change says emissions from Canadian landfills account for 20% of national methane emissions. So we're not talking small decomposing potatoes here. So it's, that was not a very funny joke, by the way. We have to have a lot of decomposing potatoes, I think, to get big quantities of landfill gas. What's being proposed here is a bylaw, a municipal bylaw that says if you want to develop a landfill, whether you're if it's a public landfill or a private landfill, we're going to not give you a development permit unless your emissions are going to be less than a certain amount annually. You have to report to us. You're going to have to engage in adaptive management. We're going to make sure this is a continuous kind of control. So the first thing we'd have to find out if this was a valid bylaw, let's say it's being challenged, is whether it's within municipal purposes. So if you looked at in Alberta legislation, you'd see that the municipal purposes include to foster the well-being of the environment and to develop and maintain safe and viable communities. Now, to me, that seems to be that would pretty squarely fit under municipal purposes. But in addition to fitting under municipal purposes, but again, that would have to be, just to come back to that Shell case, it couldn't be to like regulate greenhouse gases generally. It would have to somehow benefit the health and environment of the municipality itself. Then you'd also have to find bylaw making power, and that's either going to be specific or general. And if there's a specific power, then that cannot be enhanced by a general power. So if we looked at the Municipal Government Act, you see a council can pass bylaws for municipal purposes with respect to safety, health, and welfare of people and the protection of people and property, businesses, business activity, persons engaged in businesses. So there seems to be some general making bylaw power that might cover the landfill gas bylaw. And what about specific? Well, in Alberta, planning, development, and subdivision authority is under Part 17 of our Act, and it's under different parts depending upon where you are in Canada. But it's clear that a municipality in Alberta would have the right under under Part 17 to require a development permit for a landfill, and you could put conditions on the development permit, and I can't see offhand, just looking at the Municipal Government Act, why it couldn't put an emission limit on a permit. But there are also a number of express legislative tests in Alberta legislation, and I'm not going to go through all of them, but I have 4 of them down here. What they basically do is say, if this matter has been either authorized by the province, if a matter has been authorized by the province, and then a provincial authorization will generally prevail over a municipal bylaw, and the bylaw will be inoperative insofar as it has been authorized. Or if there's a law, a provincial law that is, that regulates exactly the same thing, then that law will prevail over it too. I just want to back up again. The Section 13 says inconsistency with an enactment, which means federal or provincial, then the bylaw is inoperative. So I have a question there. Is that spray teching inconsistency? That might well be. But the other sections use different language. They don't just say inconsistency. They say that the provincial authorization or condition of authorization prevails over, and that sounds way more like paramountcy, and so that the municipal bylaw would be inoperative. So another thing one would have to look at for Greensboro and its bylaw, landfill bylaw, is whether there are any current conflicting enactments, authorizations, conditions, or policies. Well, in my paper, I discuss various places that I looked at our waste management legislation and some of the climate change initiatives that are out right now. And I couldn't find anything that would be in any way directly conflicting with the landfill gas bylaw. Of course, if there was a provincial authorization that had a different limit, a higher limit for these methane emissions, and then that would prevail over. But without that information, you can't say for sure. But I think that the point is, I think there is probably room for such regulation, provided that the province hasn't already gone and regulated and has come up with something that would prevail over a municipal bylaw. The last one was, does the landfill gas bylaw frustrate the purposes of other enactments? And that's maybe a good question. If the province and the federal government are both keen on regulating and dealing with methane emissions, mainly from oil and gas, but perhaps moving on to other sources as well, because landfill gas is gas from biomass. It's decomposition. It's not a fossil fuel. It's a different kind of thing. I mean, if it goes on to really directly regulate landfill gases, and then it could, if it could possibly frustrate some other legislative scheme. So I can't answer for sure whether this kind of direct regulation by municipalities is possible, but yeah, these are the tests one would go through, and I think that municipalities probably have probably more power than they even think they have with respect to regulation of greenhouse gas matters. But just a word on charter cities. I was talking about regular cities. There are also things called charter cities in Canada. There's a handful of them, and Edmonton and Calgary has recently joined that handful. And their charters, they have special legislation that applies to them in addition to the regular municipal legislation. Their general bylaw making power includes, has been added to by their charters to include the well-being of the environment, including passing bylaws providing for the creation, implementation, which I have underlined, and management of programs respecting to any or all of the following: climate change adaptation and greenhouse gas emission reduction. So it's saying right there that municipalities, charter municipalities, Calgary and Edmonton, can develop bylaws to implement greenhouse gas emission reduction programs. It doesn't narrow it down to specific things, so I mean that's pretty broad. And in fact, these charters require the cities to establish climate change mitigation and adaptation plans. However, the specific legislative tests, those express legislative tests, would still apply to charter cities, and so they could be caught by those if there is provincial legislation or authorizations in place. But even if the power of municipalities to directly regulate emissions could be somewhat curbed, there are so many other things that municipalities can and are doing with respect to greenhouse gas mitigation. I'm just going to mention a few. There are hundreds of things going on. First thing I have here is 159 greenhouse gas emission reduction initiatives have been approved for federal funding of over $12 million. These are various federal programs, and this is, my computer is about to restart, so I don't know what to do about that. And then it's going to install some applications. Oh, okay, so I'll try to go quickly to the end, I guess. And municipalities can use their planning, subdivision, and development powers to reduce greenhouse gases. And I have a program here, which is a Vancouver program on which the program is by 2030, by 2050 is the far end of it, that all new buildings will produce zero emissions. They'll be built so that they will have to use the least amount of heat, and the heat sources are going to be renewable. It's really quite a remarkable program. Municipalities can implement climate change mitigation and adaptation plans. There are a lot of these on the federal site, the federal municipalities site. And one example here is a climate action plan for the Waterloo region. The Waterloo region has done a lot of remarkable things, like really cut urban sprawl and thereby cut the greenhouse gas emissions, and has implemented all kinds of other plans and have cut their emissions. Another thing they can do is they can have incentive programs for solar or wind. These municipal incentive programs can go either way. I have a Medicine Hat, Alberta program here, which will, I just have one more slide or something, so I'm okay, unless you know what to do here to get this to stop.
Just to
Just
hide
to
it.
hide it.
You don't
Okay,
want to hide.
that's right. If you don't see it, it's not there, right? Okay. Which the Medicine Hat gives utility rebates for residents who incorporate solar panels into their heating and or electrical needs. And then there are of course provincial and federal programs at all. I already mentioned some federal programs. And this is it says here that Calgary added more than 2.3 something. It doesn't want to go away. But anyways, it's offset more than 47,500 tons of GHG emissions through the installation of solar panels through provincial programs. And some of these programs are, or at least will be, funded through through the federal and provincial carbon pricing programs. So it's good to see all this money generated given to municipalities. And then finally, which won't go, there it is. No, my last slide will not come up. I think it's my last slide anyway. Like the increasing public transit, facilitating bike transportation is another thing that can be done. And my example for that was in one not far from here, which is Montreal, which is the sole North American city which has made the top 20 recycling cities in the world. In fact, it's number 20, but still, it has made that list for several years now, and so it's another way in which municipalities can use their powers and authorities to reduce greenhouse gases. So again, I think municipalities have really tremendous powers, whether they're used directly to manage greenhouse gases in exercising their other authorities, or whether it's more indirectly, for example, through making changes to their own infrastructure and the transportation systems and their plans and policies. And that's it. Thank you very much.